All right. We'll get started. Thanks for joining us, everybody. My name is Eric Hauge. I'm the Executive Director of Homeline, and you are joining us today, Wednesday, July 21st at 1:30 for a 2-hour eviction moratorium phase-out webinar. We've been doing these since mid-April last year and transitioned to some webinars focused on eviction moratorium phase-out issues at the end of last month when the phase-out began, and we'll continue to do that. We're excited today to be joined by a number of guest speakers. Alongside myself, we'll have Homeline's Managing Attorney and Hotline Director Mike Vraw speak about the phase-out, legal issues related to the phase-out. We're also joined by Rachel Sterling, who is Homeline's COVID-19 Eviction Response Coordinator and Housing Attorney. And then our special guests today are Michelle Doyle, the RentHelpMN Program Manager at Minnesota Housing, as well as Lael Robertson, who's a Policy Attorney at Minnesota Housing. And after I go through a few logistical things here, and Mike covers some points on the eviction moratorium phase-out law, some of the common questions we get. We're going to hand it over to Michelle to talk about the RentHelpMN program. We also have some slides of the most common questions that we've been getting about RentHelpMN, because Homeline, we're not experts on that program. So we're going to go through some of those frequently asked questions, and hopefully Michelle and Lael can tackle some of those, and then we'll get to your questions that are getting submitted as well. Please, if you have questions, try to use the question and answer, the Q&A button. It's a lot easier to track questions that way. So send them in. Again, we're doing a full 2-hour session today until 3:30. So we should have plenty of time to get to folks' questions. With that, I'm going to move over here to reminder about what Homeline is. We're a statewide nonprofit organization. Our main program is a free and confidential legal hotline that renters can get advice from in 4 languages: English, Spanish, Somali, and Hmong. And there's our contact information. You can submit questions on our website as well. And we advise around 15,000 households a year throughout the state. We have a lot of materials on our website that focus on the Minnesota's eviction moratorium phase out. And in a minute or two, I'll put some of these links in the chat, but the recordings of previous webinars, the schedule for upcoming webinars, and our FAQ page as well. And just a quick promo for our upcoming webinars. Next week, next Wednesday afternoon, we'll be joined by Kim Tennyson, a landlord attorney who's been on a couple of our sessions the past year, and she'll be talking from a landlord point of view perspective on the phase out. And then we just confirmed 2 weeks from today, on Wednesday, the 4th of August in the afternoon, we'll be joined by Julia Wells-Ayers from Hennepin County, as well as Jana Flinsrand from Housing Link, who are two of the organizations that are overseeing the Zero Balance Project, which again is you can reach that website, the Zero Balance Project there. That's only for Dakota, Hennepin, and Ramsey County, a program where landlords can initiate the application. So on August 4th, we'll have staff from those organizations to talk through that program and how it sort of interacts with the eviction moratorium phase out. Again, today we'll be talking about RentHelpMN. That's the focus of today's talk. But before we get to that, we'll hand it over to Homeline's Managing Attorney, Mike Vraw, to cover some of the aspects of the phase out. And again, please ask you, if you do have questions, we'll try to capture all of them towards the end of the webinar, but submit them via the Q&A system. Thank you.
Right, Eric, and when you do submit a question, it always helps us if you tell us what your role is in the process. Like, I'm a landlord, I'm a tenant, I'm a social service provider. It just gives us a little bit of perspective on the question that you submit. Again, the Q&A is our preference for that. My name is Mike Fromm. I'm the managing attorney here at Homeline, and I am the opening act today, and I'm very well aware of that. The headliners are the folks from RentHelp. They are the experts that a lot of you have been waiting to hear from. So I'm going to go through this fairly quickly versus other times when I might stretch it to half an hour or 45 minutes. But what I'm going to start with is a summary of the process, the eviction moratorium off-ramp or phase-out, however you want to phrase it, from where we were to where we are and where we're headed next. To start, we had for well over a year executive orders in place that banned almost all evictions throughout Minnesota. As we've talked about several times on this show, evictions in Minnesota have historically been filed for non-payment of rent. Well over 90% of evictions are filed for that reason, and landlords were not allowed to file evictions for non-payment of rent throughout the pandemic. That is slowly starting to change as landlords are reaccumulating rights. There was a legislative agreement reached on the 29th of June and enacted June 30th is when it took effect. And let's walk through some of the phases that we're going to see here. Go ahead, Eric, and slide the screen. Okay, so, and send us over to where we are today. Let's do that, Eric. There you go. Thanks. So looking at the phases on our chart here, you can see that we are past the July 14th date, so that was last Wednesday. The rights that landlords are, again, starting to reaccumulate, the pre-pandemic rights that landlords have, are cumulative. So the things that were talked about on June 30th, they don't go away because we're into the next phase. It's adding layers of things that landlords are now allowed to do that they weren't allowed to do before. This is, by the way, how I've almost always phrased this issue, is what landlords are allowed to do. Evictions can't be filed by a tenant, they're filed by landlords, and the eviction moratorium was in place. So the way I've always thought about this question is, when could landlords start to file evictions again? And that's what this phase out really is trying to answer, is when landlords have that right again. So the latest change, the change that happened last Wednesday, is that landlords can now file an eviction. And that's the court case, right? The unlawful detainer, the UD, cost the landlord $300 to file the case. A landlord can now file an eviction for a material breach of the lease. They weren't allowed to do that during the executive order session. But now a landlord can file an eviction for an unauthorized occupant, for a pet, if the tenant's not supposed to have a pet according to the lease, if they're smoking in a non-smoking building, making a lot of noise. This is a right that landlords didn't have for 15 months, 16 months, but now they do. Starting last week, they have the ability and the right to go file an eviction. Doesn't mean they'll win the case. They still have to prove that the tenant did what they're claiming they do, and their lease has to have some supporting portions to give them the right to file the eviction, but landlords can file for material breach. Now, this is a multi-phase process. I'm not sure that this is official in the language anywhere, but we've decided to label this as a 6-phase thing that's going on here. The next phase, which will be next month, starting the middle of the month, and they go in 30-day increments in a lot of cases. Go ahead and send the orange box over to August 13th, Eric, if you can. Thank you. Yeah, this is, in my mind, the least important of the remaining phases that we're going to see. On August 13th, the landlord is allowed to give a notice. That's different than filing the court case, not an eviction. They can't file an eviction here, a new right. They still have the rights from June 30th and July 14th, whatever's there. But the new right that landlords gain on August 13th is they can give a notice of termination, a notice of non-renewal, a notice to quit to the tenant if the tenant has applied for rent help and has been declared ineligible. And that's a new right that landlords will have on August 13th. Again, I don't think that it's meaningful. I'm not saying it doesn't matter, but it's nowhere near as meaningful as the next month's new right that landlords gain. Going on to September 12th now, if you could, Eric. Thank you. On September 12th, landlords can then file evictions. Once again, a huge difference between a notice to quit or a notice to vacate or a non-renewal or a termination and an eviction itself. Eviction is a defined word in Minnesota law. It means a court case. That's what the landlord is allowed to do. So on September 12th, landlords will be able to file a non-payment of rent eviction for a tenant who has applied and been denied, turned down, ruled ineligible for the assistance that we're going to be talking about for the rest of the day today. And so that's an important day. that landlords are going to have the right to file the eviction on September 12th. Going forward, another month from then, on October 12th, all the protections that tenants have had that have been enhanced since the pandemic began are essentially gone, except for one last one, which I'll talk about in a second. Maybe the biggest thing that a landlord has the right to do on October 12th that they couldn't do on October 11th is they would be able to give a notice to vacate or non-renewal for no reason, which is the basic law in Minnesota. If a landlord and a tenant have a one-year lease, it's not a lifetime contract. The tenant doesn't get to stay there forever simply because they want to, or because they've been a good tenant, or they paid their rent on time every month. It's a one-year deal that ends. And if either side wants to end it under Minnesota law, the landlord, for instance, can say, I don't want to do another contract with you. And right now they can't do that. On October 12th, they can. They can start to issue non-renewals, notice to termination, notice to quit, however you want to phrase those. So that'll be an important right that landlords get on October 12th. The last phase is the longest phase that we have in this buildup, and it goes through June 1 of 2022. So quite a while, a little bit less than a year from now. But during that time, a tenant can't be evicted, once again, for non-payment of rent, which in this state is why landlords evict. That's just how it is. There are some exceptions to that, but in general, again, 90% plus of evictions are filed for non-payment of rent. And a tenant is protected through June 1 of 2022 if they've applied for rental assistance and they have a pending application. That's what the law says. So a long time in place that the tenant has the right to try to collect this money from the state, get it sent to the landlord, and hopefully get caught up on their rent. So those are the phases. There's a couple overarching things that I want to mention. The first is a notice requirement. And that is in place through October of this year. Now, this is new for Minnesota. In almost every other state in the country, a landlord is required to notify a tenant before they are able to file evictions. But in Minnesota, they're not. So pre-pandemic times, if the rent is due on the 1st, on the 2nd, the landlord can go to the courthouse and file an eviction for non-payment of rent. Now, landlords don't generally do that, but they have the right to, and sometimes they do that. But now, until October 12th, a landlord has to give a 15-day notice first to the tenant that has to have a few pieces of information in it. First, a statement that the eviction moratorium has ended and that the tenant can be evicted. I actually spoke to a group of landlords today, and we talked about the fact that a lot of tenants aren't really sure where the footing is. There's a lot of information out there and they don't know which applies to them. So this 15-day notice does that to start with. Hey, tenant, that moratorium you've been hearing about for so long, it's gone and I have the right to evict. The next requirement of the notice, the landlord has to state how much rent is due. Now, the law doesn't say that the landlord has to say how much the late fees are, utilities, just rent. But if I'm a landlord, I'm going to write down every penny the tenant owes me, rightfully, because that's how I'm most likely going to be able to hopefully get the money from RentHelp. Next, it's supposed to state this notice where the tenant can go to get rental assistance. 211, RentHelpMN are the things that are cited in the law that we have. There are some odd pieces of how this notice can be given. It has to be in writing, and it's got to state those three things. It doesn't say how the notice has to be delivered, but it does have to be given to the tenant. Is an email sufficient? Maybe, if the landlord and the tenant have a long-term email back and forth relationship, so it's less likely to be going to somebody's spam filter right away. A text almost certainly is not sufficient notice by most court cases, not on this exact issue, but asking whether a text message is sufficient notice in important legal type matters. Generally, the answer is no. Maybe that'll shift over time. But a piece of paper is the safest route for the landlord to go. They don't have to notarize it. They don't have to have a process server give it, but a written notice does have to be given. Even if the tenant at right now is refusing to apply for help from RentHelp, if the landlord wants to file an eviction for non-payment of rent for that reason, which is the one non-payment of rent reason a landlord can file today, then they still have to give this 15-day notice of non-payment warning saying that the eviction is coming. And the last overarching thing about the Minnesota eviction moratorium off-ramp or phase out is we've mentioned this already, but go ahead and go to the next slide, Eric. The protection for a pending application lasts through June 1 of 2022. I think this is the biggest bolded thing that we have in any of our presentations because it's really important. It's very long lasting. And so it's critical that everybody understands that. And it's also important that landlords understand that they're, during that time, hopeful to get paid. It's realistic to get paid. There's real money out there that's going to be talked about today. But that's why this protection lasts so long, is because we're hoping that everybody that should get paid, all the landlords that should get paid for tenants that are behind on the rent, do get paid. I do want to touch briefly on the federal moratoriums because they're in the news and one of them still has some importance today. The first one is the CDC federal moratorium on evictions. The Center for Disease Control, a lot of people have heard about this. It's in the media quite a bit, and we're going to see this ramp up in the next 11 days. You're going to see it on national media, all over social media, how an eviction flood is going to happen around the country. Minnesota, with its off-ramp built in place, isn't really impacted by the CDC moratorium. It never really has been. It's always sort of been something of a backstop. So we haven't spent time talking about what the tenant really needs to do to qualify for the CDC protection. They're supposed to send a declaration of how they lost income because of COVID and that they've tried everything they could to get the money back. Not required in Minnesota because the CDC moratorium specifically defers to a stronger local protection, whether it's a state or a county or a city. So it's never really played a role, but you're going to hear about the CDC moratorium in the next 11 days a lot, like I said, through media and social media. But just keep in mind that in Minnesota, not much of an impact. And it never really did have that much of an impact in Minnesota, other than being, like I said, a backstop. The last federal rule that I'm going to bring up is something called the CARES Act, which is, if you remember right, from the early days of the pandemic, there was federal legislation that was enacted March, I think it was March of last year, might have been April, very bipartisan. That's where the first checks were sent out to citizens of the U.S. To help supplement their income because so many people had lost their income. There was a lot of pieces to this legislation, the CARES Act. The part that we care about, the part that still matters, is a landlord-tenant part. So to start with, the CARES Act stopped evictions nationally for CARES Act covered buildings, and I'll talk about that in a second, through July 25th of last year. That period obviously is over, and it did not get renewed. It, as they say in legislative speak, it sunsetted. However, after July 25th, the CARES Act required that a landlord, if they wanted to file a non-payment of rent eviction, was required to give a 30-day notice to the tenant. And that notice is still in place. It's still required. It did not sunset. So in theory, a landlord, I guess forever, in a CARES Act covered building, unless that law gets changed or court strikes it down, has to give a CARES Act 30-day notice saying, hey, you know what, your rent is overdue. I'm going to file an eviction in 30 days. So who's a CARES Act covered building? Well, to start, any building that's got almost any type of federal subsidy. If you want the definition by the statute, you'd say a quick look at the VAWA statute, the Violence Against Women Act, and that lists all kinds of buildings that are covered by VAWA. And it's the same under the CARES Act. Additionally, and more difficult to figure out, is federally backed mortgages, something like Fannie Mae or Freddie Mac, where a landlord has a mortgage backed by that. Now, in many other states, state Supreme Courts have issued declarations that all lower courts had to require that I'm sorry, I lost my train of thought. My mind caught a question that was being submitted, and that's where I went straight from there. Anyhow, 30 days requirement is what we have, and this is hard for tenants to know if a landlord has a federally backed mortgage. Probably the only way it's going to be a knowable fact is if the landlord either discloses it or there's discovery, which is quite uncommon on a kind of traditional litigation sense when we're talking about evictions, which are summary proceedings. They're done pretty quickly. So we'd love to see Minnesota have a rule in place that says that landlords have to swear under oath that they are either a CARES Act not covered building or that they've complied with the CARES Act 30-day requirement. But so far, we haven't seen that kind of thing. We'll see how courts deal with it going forward. But it is something that could play a role, like I said, into the future is until it's, again, overturned by court or legislatively. Okay, I think that's my time. And I think I'm going to go ahead and wrap it up because I'm not really taking questions today. They're mostly going to be about rent help.
Right. Thank you, Mike. And we have been getting some questions related to the phase out and tenant landlord issues. We will hold those to the very end if we have time. So we'll try to tackle RentHelpMN questions first. So with that, I'm going to welcome and thank both Michelle Doyle and Lael Robertson from Minnesota Housing and hand it over to them to give an overview of the RentHelpMN program. And then again, we do have a sort of a series of categories of questions that we've gotten commonly on these webinars that we'll go through, and then we'll hand it over to some questions that have been submitted. So welcome, thank you.
Thank you for having us. So the RentHelpMN program is a program for federally funded assistance. We have about 200 million in ERA1 funds, and then another 200 and something million in ERA2 funds that we are not using at this point. That will come at a later time. We have a centralized application so that there's one place to apply. There's one place where all your information, your landlord information and the tenant information will be at. Also central 2-in-1 service. So if applicants have questions or they would like to check the status of their application, or if they would like to leave a note to their case manager, these are services that 2-in-1 can provide. We also provide community navigators as well. So if a tenant is having some questions or concerns or can't fill out the application on their own, they can contact 2-in-1. 2-in-1 will assist them with finding a field partner, and those field partner and the client can work together to get their application completed, and also work with the case manager that is processing the application to assist the client in any means whatsoever. And those provide all different, our field partners provide all different services, language services, services for those with disabilities that are just not able to complete the application. We do have an online system for our application that the registered applicant will register for. They can go in, upload their documents. Once it's submitted, it cannot be changed until the caseworker will reach out to see if there's any changes that need to be made. The landlord can also register and is encouraged to register because the landlord will be able to see any applications that are attached to their property. And one thing that comes up is sometimes the landlord can't see an application. They know that their tenant has applied, but they can't see it. If the tenant didn't pick the correct landlord that registered, then when it's time for processing the application, the case manager will attach the landlord to the property, and then they'll be able to see what the status is and where it is in the process. We do have 2 phases of the rent help program. Right now we are in phase 1, which is for past due rent arrears. Also, you can ask for up to 3 months of future rent, up to 15 months at this time, past due utilities and any other fees that will be applied to the housing stabilization. We will have phase 2 at some point, and at that, during phase 2, applicants can apply for future rent up to 3 months at a time, or utilities that are past due, or fees. But at this time, it's just phase 1. We can go to the next slide and talk about the phases of the application, because I think this is important. So with the off-ramp, in order for an applicant to qualify for the off-ramp, they must have a submitted pending application. Incomplete applications do not qualify. If the applicant has not submitted their application, it will not qualify for the protection under the off-ramp. After it's submitted, it will go through many stages, and those stages can change and statuses can change a number of times. It goes from pending review to initial review. And then if there's things during that phase that the caseworker or processor finds, it can go back to pending review until that information is cleared up. It goes to applicant response, and that is when the application is opened back up for the applicant to make any changes that are requested, upload any documents. After that, it goes to final review, that is when the landlord is contacted to make sure that the assistance is correct for what the applicant applied for and verify it against the updated rent ledger. We do ask that applicants and landlords upload rent ledgers for the applicant so that it can show what exactly is needed. Once that is completed, the landlord will approve the application, and then it goes to final review, any other QA things that need to be done, and then it will go for approval. And then funds will be submitted. And the status will change throughout the process. And on the dashboard for the applicant and the landlord, you will be able to see what is going on. I think next is the Q&A slides. We can go through those questions. So can landlords apply for rent help for the tenants? They cannot apply and complete the application for their tenant. They can invite the tenant to apply for RentHelpMN. There is no landlord application where they can get the assistance that the tenant needs. The tenant has to apply and complete the application. Can I apply for rent help if I do not have a lease? We do offer resources on our resource page that can be used instead of a lease. It has to be signed between the landlord and the tenant. We offer rent ledgers. If there isn't a formal rent ledger that is used that needs to be completed, there are plenty of resources on our website to assist if there are issues completing the lease, ID forms, changes of household. There are a lot of resources on there that can help out. So to qualify for the rent help program, you have to be below the 80% AMI. You have to have be a renter, have a mobile home. And the income limits are listed on our website for each county, because county income limits do change per the guidelines. So that is what we use to qualify to see if the person meets the income guidelines. That'll be, the next question is a Leo question.
So we're at the tribal?
No, if the tenant is behind and they know they don't.
Oh, I'm sorry. No. Sorry, I was 2 steps ahead. Okay, tenant is behind on rent and they know they don't qualify for RentHelpMN, but apply anyway and are denied because they don't qualify. Do they have protections for non-payment until August 13th? So for non-payment, the chart, I believe, shows that on August 13th, if they are ineligible for rent help, then August 13th is when the landlord can file an eviction action. Is that correct, according to the chart, Eric?
August 13th is termination and non-renewal of leases for those ineligible, behind and ineligible. September 12th is eviction filing day.
Thank you. So if the only issue is non-payment, then there is protection until August 13th if they don't qualify. If there are other issues like breaches of lease, they could still have an eviction action or termination based on that. But as far as the non-payment, if they're ineligible, they are protected until August 13th from a termination.
So the next question is, how many times can a tenant apply for assistance? They can apply for assistance up to 15 months at this time. So 15 months of rental assistance, utility assistance, and any other assistance that qualify for the program. So if they have 12 months of past due rent, they would qualify for 3 months of future rent. It just equals the 15 months for now. And then the next question is Leo.
Now we're on the tribal members. So the should enrolled members apply for rental assistance with their tribe if they live off the reservation. Really, that's a personal choice. I mean, what we're asking is that you don't apply at more than one place, because the problem with that is we spend time and energy trying to make sure that duplicates aren't paid by two different entities. But really, enrolled members need to speak with their tribe directly to see if they qualify for their program. And then figure out if they qualify for rent help, but it's not it's really an individual choice as to where they apply.
All right. So you can tell that a tenant applied if they are attached to your property on your dashboard. That will show that their application is pending. Eligibility, you can read the list of eligibility on our website, and you can see if you think they qualify. However, the rent help application will make the final verification on whether or not the applicant qualifies. We do have a landlord section on our website that offers a lot of helpful information for questions like, my dashboard and my applicant aren't connected. How do I get help? The email address for our landlord helpline. 211 will not tell landlords information or anyone that calls about an applicant due to privacy concerns. They have to speak to the applicant themselves to answer a question regarding that application. And they do verifications to make sure that they're speaking to the correct person.
And you said, Michelle, you said that if a landlord is connected into the system, if they're connected with the tenant application, they should be able to find status that way.
Yes, absolutely. It'll be on their dashboard.
And if they're not connected, then we have ways to connect them.
Yep.
Right.
And we also have a video on our website on how to register, how to approve an application for the landlord. That's very helpful. How will a landlord prove a tenant is ineligible for rental assistance, or how will the tenant prove eligibility? Well, it wouldn't be up to the landlord or the tenant to prove eligibility. Once the application is processed, if the tenant is eligible, they'll be processed. If they're not eligible, the application will be denied.
I also want to just clarify that, that the statute says that on August 13th and then subsequently for termination, and subsequently on September 12th for eviction actions, that tenants who are ineligible for COVID-19 rental assistance programs can be terminated and then evicted. They do not have to apply to establish that ineligibility. They may be ineligible income-wise, but the landlord does need to prove in court the ineligibility. And so when landlords are thinking about whether or not they want to terminate or bring those cases, just understand that the court will have to have proof of the ineligibility. A good way to show that would be if they have gone through the system and been deemed ineligible, but not everybody's going to do that. So, I mean, just understand that there's a level of proof that landlords have to show the ineligible, and a tenant does not have to go through the system in order to be deemed ineligible.
And also the tenant, the applicant, when they complete an application and they submit it, they do get a letter that states that they have applied for rent assistance. And it does state the amount on there that they've applied for, which can change depending on the verification throughout the process. But it does state that they have applied and this is their application and when they applied.
And as Michelle pointed out, in general, eligibility is a pretty, I mean, it's a pretty low bar to be eligible for this program. I mean, Treasury has made that very clear. You can find out general eligibility criteria on our website on RentHelpMN.org. So you can take a look there if you're wondering what does it mean to be eligible or ineligible for the program.
And then incomplete applications do not protect against the eviction moratorium. It must be a submitted application, which would make it in one of the many statuses, pending initial review, those different statuses. But if it is incomplete and says it is incomplete, it would not qualify. Are the applicants protected from eviction if their application is denied? If they're denied due to ineligibility, then they wouldn't be protected. If they are denied for another reason and there's an appeal, they would be protected through the appeals process. And then if they're denied after that, then they would not be protected.
I'll take this area, the refusal to participate. And Mike, feel free to jump in at any point if you'd like. So landlords are telling us they're not going to participate so that they can proceed with evictions. If the landlord refuses to participate, the money would go to the tenant. That is true. So refusal to participate by the landlord still allows tenants an opportunity to get the amount of money owed, and it goes directly to them with the understanding that that money is going to be used in the way that, you know, for the owed amount that they have given or submitted to the program. So a landlord stated, sorry, yeah, go ahead.
If I could, so the
Please.
presumption there is that the tenant would pay back the old debt. Is that the theory, even if they've been evicted?
If they have been evicted, then they don't qualify for the payment, because once they're out of the property, we can't pay back. If they're out of the property and they don't have possession anymore, then we cannot pay past debt at a place that they aren't living anymore.
What if they, I mean, kind of four people pull up to a stop sign and you have to decide who goes first. What if they get the check on the day of the eviction hearing?
Oh, well, okay. So if they get the check on the day of the eviction hearing and there's still an opportunity to redeem, then they can go ahead with that money and pay the redemption. If there's additional money that's owed through court fees, then they can apply for those as well. Then they can ask for court fee.
How would we know that the tenant used the money for that purpose at that point, since the check goes to them directly?
Yeah, that's a good question. I mean, they certify to us that the funds are going to be used in the way that for which they have been requested. So
that would rule out paying the next landlord because they were requested to pay the old landlord, right?
If they requested to pay the old landlord and they still have the ability to redeem, and what that means is that they get their property, then the expectation is that the old landlord would be paid and that they would be able to redeem that and stay in the property. Does that make sense?
It does. It's just there's that gap time, you know, in the eviction process where if the check came, and it came to the tenant, I'm not sure exactly what the tenant's going to do with the money or would be required to do with it.
Right.
Because they're going to have this, are they supposed to return the money to you if they can't redeem? Is that what we're expecting?
Michelle, can you talk to us through that? Because I thought that there was some clause, I don't know, that may be a conversation that we take offline about if for some reason they can't pay the landlord, what can you do with the money? And I think there might actually be some Treasury guidance on that, but I can't think of it right now.
And maybe that makes sense for September 13th session. Maybe we could have you guys back for then, because we'll have a better sense of that. It's not really the today question, frankly.
Right.
It will be the question eventually.
Right. Agreed.
Okay.
And it's possible that by September 13th, I don't know, I'm not talking about any timelines, but as Michelle pointed out, we're going to have a phase 2, and that phase 2 is forward paying rent, right? So rules are going to change a little bit in that we're going to be able, what Treasury says is if you have if you're kind of under contract with a new landlord for the future, that you will be able to use funds into the future, even without having the past debt paid, if that makes sense.
Sure. Thanks.
Yeah. So a landlord stated they are going to say the tenant doesn't owe anything, so the tenant does not qualify for rent help, and then they can proceed with an eviction. Is this valid? Well, number one, it's not valid. And number two, I don't think it's going to work because you need to understand that if a tenant submits an application to rent help, and rent help staff reach out to the landlord and the landlord says, oh, they don't owe any money, there's going to be documentation of that. We're going to have it in the notes section. They're going to be denied for not owing any money, and there's going to be a paper trail of that. So then if a landlord then goes to eviction court for a non-payment claim and saying they owe me all of this money, the reality is we have a paper trail that the landlord has previously said that they don't owe money. So I'm not quite sure what the landlord's ultimate goal is there, or I feel like I don't think it's going to achieve what they want it to achieve. You cannot evict someone for non-payment if there's a record of you telling a state organization that they don't owe any money. Or I think it would be hard. I shouldn't say that because I can't read the mind of the judge, but that would be my comment to that. So what constitutes a tenant's refusal to participate? How do we verify tenant is eligible and not just saying they have applied, installing the application by not uploading documents? How long do landlords have to give tenants to their assistance for rental? Okay, so I'm going to break this down. So what constitutes a tenant's refusal to participate? I can't answer that. I do think that that's going to be something that's going to have to be answered in the courts. The reality is that's the lines that are getting drawn there. It's in statute, but there's no, we don't really have any direction around that language. So that's just going to have to be decided in housing court. How do we verify tenant is eligible and not just saying that they have applied, then stalling application by not uploading documents? Well, the first piece is, as Michelle said, as a landlord, for landlords, we would strongly encourage you to get your information into the system so that your tenant can be connected to you and you can see on your dashboard who has applied, who is in pending status, and or whatever status they are. So if you can get into the system, and if you get into the system, but you know some people have said that they've applied and you don't think they're connected, as Michelle pointed out, we do have ways to make sure that you are connected to the applications that are going for your property. And are they stalling the application by not uploading documents? So our program guide does give a window by which tenants have to respond to requests for information. So the program guide, which is on RentHelpMN.org, says that if our processor has made 3 attempts within a 21-day period to reach the tenant and there has been no response, then the application will be closed without the ability to appeal. So there is a timeline that the tenant has to produce information, to correspond with the processor, to move the application forward. And if they don't, then our processor has the ability to close out the file. How long do landlords have to give tenants to get their assistance through? How long do landlords have to give tenants to get their assistance through RentHelp? I'm not quite sure I understand. Like, is this question that a landlord says, go do this, and then how long do they have to wait until they decide that the tenant isn't participating? If that's the question, again, I don't really have an answer to that. Usually it's a reasonableness standard, but that really depends upon all of the tenants. So again, that's going to be a court to decide whether or not the amount of time that you gave was reasonable, whether or not it was unreasonable for the tenant to not have applied during that period of time. So a lot of these questions, we just have to wait and see what the judges and referees are going to do. All right. Do you want me to do this one too, Michelle? This question?
Yes.
We were talking about late fees. So what are the legalities for late fees being charged by landlords for late months during COVID? How about months that a tenant has a pending application with RentHelpMN? Funding was approved. And then I was approved, I'm going to kind of rope these two together. So I was approved for RentHelpMN to cover back rent, current rent, and 3 months into the future. My landlord has charged 2 late rent fees per late month. These fees are well over the 8%. I do not want the landlord to get paid for late fees if they are not legal. Also, can the landlord charge late fees for the late months the tenants had pending RentHelpMN application? So there's, so the first thing is RentHelpMN will pay for any legal late fees that happened during the period of time that you're asking for rent. So what that means is that our processors will be looking at the late fees and determining whether these late fees are in the lease and whether or not those late fees are at 8% or below 8%. So they will be making sure that those are legally charged late fees. It's been a long time, but I believe under the CARES Act that buildings covered under the CARES Act were not allowed to charge late fees under that eviction moratorium, or under that, yeah, I believe. So any of those late fees that were for CARES Act buildings should not be charged as well, and we would not pay those. But any legal late fees can be covered by RentHelpMN dollars.
And the CARES Act was, I think, like March through July of last year, right? I think that was the period.
Well, did Mike say, I couldn't remember, was it June 25th, 2020? Is that the date when that ended? The late
July
fee?
25th, right? So I think late
July
fees,
25th? Okay.
yeah, I think late fees for the CARES Act buildings prior to July 25th of last year certainly can't be charged.
Right,
But after July 25th, I think they can be.
right. Yep. So that's another one of those, like, we can pay for legal late fees. So we'll be looking at that. Okay, I'll take this first one too, Michelle. Protections for undocumented tenants in RentHelpMN. What I can tell you is that questions about immigration status or document are not asked, and documents showing your citizenship or non-citizenship status are not requested, or required, or encouraged. We don't want you uploading any of that information.
So the next question is, if the landlord non-renews or terminates the lease for material violations, can the landlord still rent help funding? No. So in order for the funding to be approved, the tenant has to still be an occupant at their primary residence. So if the check is sent today and the tenant moves out tomorrow, the landlord needs to send the check back when they receive it. They have to still be part of the tenancy of the property.
And the expectation is that they will be living in the property for the duration of the money that you receive. So if you, as Michelle said, if they have past rent due from March, April, May, June, and then the tenant, and then you see in the check that you're sent also July, August, September, the expectation is that that tenant will not be evicted or terminated for non-payment through September. Or you will have to return the money, I assume.
And if the tenant moves out, has received assistance, you receive the 3 months of future rent. The tenant's last day of the lease is July. They ask for August, September, and October future rent. You are expected to return the money for the future rent and any additional rent from that month. So if they moved out on the 15th of the month, that middle amount of rent is also expected to be sent back. Price gouging and rent increases, I believe that would be a legal
Yeah,
question.
I think if you have questions like that, I would encourage the tenant to seek legal advice, to call Homeline or to call legal services to see what sort of, because there is law around unconscionable rent increases and price gouging.
So the next question is, if the tenant has not applied for assistance and then applies for assistance after the eviction, who is responsible for the court fees? The court fees, eviction fees, can be reasonable fees that are applied to the application for assistance. If the tenant is denied by rent, can they apply for zero balance program? We do have the same criteria per the Treasury guidelines as far as what is needed for compliance. So the rules are pretty much the same on both programs. So if they're denied in our program because they don't meet the eligibility, they would more than likely be denied in the zero balance program for eligibility as well. Besides RentHelpMN and zero balance, will there be any other COVID relief under the phase out law?
Any other programs? Well, I believe that St. Paul may be starting one. There are tribal programs, and that's kind of why that language was a little broader, because we don't know what other municipalities or other localities are, if they're creating programs or if there will be other programs. So that's what we know so far, is that Rent Help, Zero Balance, potentially St. Paul, there are tribal programs. Dakota County is part of RentHelpMN. So that's what we have right now.
All right. Well, thank you. We have quite a bit of questions that are piling up. So And the last couple questions here about zero balance. So a reminder that we are going to have zero balance folks on 2 weeks from today. So we'll get some questions answered about that program then. But we have just a handful of questions that were submitted by participants in advance, and then we'll get to the live ones here. And Rachel is going to be, we're going to go back and forth with these questions here. So I'll start with a question from Skylar, who we think is a service provider. And again, some of these are going to be repetitive because Michelle and Lil did a great job of covering some of the key points of the program and already answered quite a few questions here. So if they're duplicative, forgive us, and if there's any more that should be added, we can add it. So Skylar asks, the application review process can take some time. Will approved applications automatically cover full amount owed?
So in that case, if our application process is taking a little long right now, we have some hiccups and we're working on that to make the process move smoothly. We do ask for verification of the amount owed during the application process and the review process. So we will reach out to the landlord to get an updated ledger. So if the ledger was submitted in April, we'll ask for a new updated ledger for July that shows what the new fees are. And if there's any additional fees or rent added to that, or make sure nothing was paid, or just to make sure everything lines up.
Okay, thank you. We have a question from David, who's a landlord, I believe, and they ask, I've had tenants whose status has shown funding approved for X number of months, but no payment received. What's the holdup or next step?
So if there's a payment that says funding approved and it's been a few months, we do ask that you reach out to the landlord's line and let them know that you have not received the payment. And then we will look into it to see why that hasn't happened.
All right, a different David, a service provider is asking, and this might be a question, Rachel, you might know this too. Are there going to be people to help sign tenants up for RentHelpMN at the Hennepin County Courthouse while evictions are in session? Do you know that?
We were talking about that a little bit this morning, and so I think that is something that the legal aid providers are hoping to be able to do with folks who are going to be going through. Hennepin County is going to be virtual for a while longer. So the process, my understanding is that the legal aid attorneys will be available in their attorney room, breakout rooms, but not certain how much they can walk a tenant through actually applying with that process. They at this point. Lil, do you have anything else to add from that conversation we were having?
Yeah, I guess what I can say is that that's something that's really important to everybody in the housing community, to make sure that people have access at the courthouse. So we're looking into different ways to staff that. We're working with court administration to make sure information is at the courthouse, virtual and real. And I guess I can say, stay tuned.
I suppose I'm up for questioning. All right, this one's from Kim. Your program, RentHelpMN, says the 3 months goes forward from the date of application was submitted, but we're now going into 4 months to process applications. In our landlord portal, the dates are changing. The status is changing, sometimes backwards from funding to initial review. How do we know what dates are actual? And then how does it go from submitted to funding back to initial review? You kind of covered that a little bit. And finally, once submitted for funding, how long before funds should be received? We have several for weeks now. So I've just threw several different questions at you. I can repeat them if you would like.
No, I think I have it. So once funding is approved, we go through the final process, verify with the bank that the payment can be sent out, if it's EFT, if it needs to be a check. Once that goes out, the status will change to payment sent to show that the payment has been sent out. We are doing some reconciliation to make sure that all the ones that are funding approved and payment sent are matching up. The next question, the timeline. So say an applicant applied for rent help in April, they asked for 3 months of future rent for March, April, May, June, and July. However, the application isn't processed yet and we're in July and they're processing it. They will be able to ask for 3 additional months as long as they have not met that 15-month cutoff. So if they were late from April to April, and then they asked for May, June, and July, they would be at their 15 months and would not be eligible at this time for additional rent assistance. But we do clarify with the applicant if they would like to add that additional 3 months. So landlords can add that when they edit the request amount, but we verify with the tenant that they want to apply for that additional 3 months. All right, was there another one in there?
They touched a little bit about the changing statuses, but you had covered that a little bit. If you want to just give a brief recap about how a status can change from submitted to back to initial review and things like that.
So it can change for a number of reasons. If it goes to requires applicant response, we get paperwork from them that says something different than is on the application, then we will make it pending review. And then we may have to go back to applicant response to get more clarification because of the documents submitted. It can go to landlord review. And then if the landlord adds 3 months in there, then it goes back to initial review so that the case manager can reach out to the applicant to verify that they are okay with the assistance that was asked for in advance. So there are many times where the application status can change multiple times. One thing I can say, and that we have encouraged since the beginning, if landlords and applicants work together on their landlord checklist and their tenant checklist to submit the most accurate and application, it does make the process go a lot smoother because the documents that are requested are already in the system and we only need updated information, and that makes the application go faster.
Thank you.
You're welcome.
Question from Justin, a service provider. Is there any shut-off protection with utilities?
So it does say on our letter that they have applied for assistance for utilities. And I understand because of the process being a little bit longer that they are getting shut off notices and some are applying for additional assistance through LIHEAP or whatever community organization. Applicants are more than welcome to apply for additional assistance through programs that may process their utility assistance quicker. They have to let us know that they've applied so that assistance on their application can be removed because they cannot get dual assistance from multiple programs. They have to let us know.
That's good to know. And a helpful resource on this front is the Citizens Utility Board. I'll put their website in the chat and renters can contact them to get advice about consultations around what might be best for them to apply through seeing a shutoff if they can't afford utilities. Rachel, you want to do that one that was in the chat?
Sure. Okay. Absolutely. This is from an anonymous person, but can we cover and talk about back utilities portion of RentHelpMN? I get clients that come in and are getting utilities being shut off. So if I help with energy assistance, this is, sorry, there's some X's in here. So if I help with energy assistance and we help pay off X dollar amounts and the person signing up for rent help reports that they owed X number amount, which is now lower. I think this was the question that you basically just asked. So I think that's already been answered. So I'm actually going to go to the Q&A, Eric, if that's fine by you.
I just want to highlight what Michelle said about LIHEAP. So if you have applied for utilities and rent with us, and you'd like to apply someplace else, you need to tell us. But I do know that the Department of Commerce through LIHEAP, which is, I believe, low income heating and energy assistance program, I think. But basically it's an energy assistance program through the Department of Commerce. It has the ability to pay past due utilities as well as give you credit for forward utilities. And I don't know what their timeline is right now, but they may be running faster because they're only doing utilities as opposed to housing and utilities. So I think that the Department of Commerce has a link on their website, but Eric, maybe if you could find that, because you can apply for utilities with them and then apply for rent help with us. And so just wanted to flag that.
Thank you for that clarification, Leo. I'm just going to start at the top and work our way down. And so this is from service provider. Andrew is asking, so they got a letter from a law office stating that the property management company, that the owner does not intend to continue with the month-to-month agreement. Oh, never, this is a legal question. All right, here's one. I'm a landlord. What should we do if tenants show up on our RentHelpMN dashboard for properties that we do not own?
So in that case, we do ask that you email the landlord's assistance email address and let them know the application number. That's really all. Please don't put any private information in email, just the application number, and let them know that that applicant does not live in your property so that they can connect it to the correct property. And I also will say, because there has been some questions about responses from the landlord email address. If a response, so you send that, let us know. I cannot guarantee that the person that is working will respond to you with an answer. They will take the information and they will work with that information and get it corrected.
Michelle, do you want to give that that email address? Maybe we could put it in the chat.
Yep, I can put it in the chat.
All right, thank you. And while Michelle's putting that in the chat, I'm just gonna, there was a question about CLE credit for today for landlord or tenant attorneys, and the answer is yes, we will. Well, we don't know if we're going to get CLE credit, but we will be applying for CLE credit for today's session. We applied for June 30th and we still haven't heard back yet. So it does take some time, but we'll follow up with attendees once we get approval. And then with that, I'll jump to the next question. I hope this wasn't the same one from Lucas. No.
Yeah, Lucas had a couple of different questions.
Okay, so what is the procedure if a tenant receives assistance from more than one program? Can this be applied to prepaid rent, or are we to send the payment back?
So if the applicant applied for 2 programs, then the payment needs to be sent back. The applicant cannot receive assistance from 2 programs for federally funded assistance.
All right. This is a RentHelpMN question, but I think this is going to be more for Eric or for us. Asking, can Homeline provide translation services between the landlord and the tenant if there's a language barrier in requesting proof of application from the tenant? So I'm going to expand on that a little bit and also put to Michelle or Lael what all languages other than English are options with RentHelpMN.
So we have Somali, Hmong, and Spanish. And we also have field partners that work with various languages and clients with various language needs. So if the applicant is working with one of those field partners, then the applicant can have their field partner maybe contact the landlord and get them the information that they need.
Yeah, and with those field partners, if there's another language that's needed, the field partners can make it happen, that whatever language they need assistance in, they can be assisted through a field partner.
And so on that same question, so Homeline, we do have staff and we specific language lines for English, Spanish, Somali, and Hmong languages. So we can advise tenants about their rights in those languages. I think maybe it's probably in the best interest of a landlord in this situation to encourage the tenant probably to call 211 to get connected to a field partner if the tenant is not already. That's what I'm hearing from Michelle and Lael, I think. Yeah. All right. Carmen asks, for RentHelpMN, can a landlord withdraw an application due to already receiving funds via a tribal program? Tenant has paid up on their own, or tenant has moved, or due to death? Any of those categories?
So a landlord cannot withdraw a client application because the application is the client's application. What the landlord can do is contact RentHelp, let them know about the application number, the circumstances behind it, and then we will verify with the applicant that the withdrawal is necessary. But yes, if you know that your client has moved out, they applied, we encourage you to let us know so that we can do the verification and withdraw them, because it will affect future assistance that they can receive if we don't know.
Okay. Emily has the same question essentially about canceling applications for tenants who moved out before they vacated. Sounds like the answer is no, that has to be coming from the tenant. The next one is about it's about notice. All right, here's one from Valerie. When is phase 2 rolling out? When will property management see checks after the time of funding approval?
So we don't have a date as of yet when phase 2 will be rolled out. We will definitely update our website to show when phase 2 will open up. And then the property management will receive checks as soon as the verification and approval and things that need to be done for the check to be sent, and that status will change in the application to say payment sent.
All right. Brianna has a question. If a client receives one-time rental assistance from a non-federally funded nonprofit, so I'm guessing rental assistance from something other than the programs that are in the phase-out law, will they still qualify for RentHelpMN funding?
They would qualify for assistance not already paid. So if they received assistance to cover their April through July rent of 2020, they cannot apply for that assistance to cover that rent. They would apply for assistance that has not been assisted.
All right. Okay, I think I understand this question. Sorry. It's from an anonymous person, but saying several field partners have mentioned that if a tenant gets assistance from Minnesota Rent Help for utilities and not rent, that it's considered time off of their potential months of rental assistance. Is that correct?
So it is 15 months of total assistance. So say that you have April and May rent, only June utilities, July, that June counts as 1 month of just the utility payment. So it's 15 total months of assistance, no matter what you get the assistance for. So if you don't have missing rent for 1 month, but you need help with utilities, that does count as 1 month.
Thank you.
Emily asks, and this might be more of a legal question here. Emily's a social service worker with a client that received a 15-day notice. The notice did not mention the part about how or where the tenant can get help. Does that make the notice invalid?
So I guess Mike, feel free to jump in at any time, but the statute lists 3 different pieces that need to be included on the notice. But then the statute also says that it's not a strict compliance standard, it's a substantial compliance standard. And that's just a standard that we're going to have to wait and see what the court says about that, about whether 2 out of 3 is substantial compliance, 1 out of 3 is substantial compliance. So again, it doesn't necessarily make it invalid. I think the question is whether or not there was substantial compliance with the statute, and that is going to be a legal question that we have to wait for the courts to determine.
Right, Leil's right. There's some confusion here. The statute itself says that the landlord must provide the written notice with the following information. And must means a lot in statutory interpretation. It's not may, which would be very different than must. So it says must, but then it has what Leil just mentioned, the substantial compliance sort of shelter that the landlord might try to use. As a tenant attorney, I would absolutely make the argument that the landlord has not complied with the order, if that's what we have. But we don't know until the judge rules on it.
I do want, this isn't associated with any of the questions, but I just do want to toss one thing out that had been brought up at some past meetings that we've had with advocates and with field partners, asking about the submission of materials. And I've heard that there's a little bit of confusion about, well, what if I don't have an ID that has my picture on it? Or what if I don't have proof of my income, like I've been getting income and I can have an employer verify it, but I don't have like a pay stub. It's really important for you to take a look at what we have online, as there's kind of like an a la carte of what you can submit for each requirement. There are lots of self-attestations and certifications where your clients or you can say, you know, under penalty of perjury, or, you know, I'm not lying. This, I am who I say I am. I don't have an ID that has my name and my face on it, but I am who I say I am. And that can be submitted as your proof of ID, or the same for several other of the categories. So look at the resources that are online and look at the options for different ways to meet the different hurdles. There may be some there that you may not have seen before.
All right, thanks, Leil. I forget if it was me or you, Rachel.
I also don't remember. Sorry. I will. We can start at the top and keep going.
I was just going to say one quick thing. We got 45 minutes and we got 34 questions. I think there's probably some duplication, so I think we can plow through it. But just for the sake of time, we're just going to plow through in order, and so we may get some non-RentHelpMN ones, but we'll get through them, and either Rachel or Mike can field some of the non-RentHelpMN ones. So I'm going to start with Andrea's.
All right, absolutely. And this is probably going to be one more for Mike or myself. So Andrea works in social services, and they got a letter from a law office stating that the property management company does not, and the owner does not intend to continue with the month-to-month agreement currently in place. It goes on to say that this is a courtesy notice and that the owner does not intend to continue with the tenancy when it becomes a viable option to end the rental agreement. This was a copy that was sent to Andrea and the client. Is this another way around an eviction? The tenant is behind on rent, but needs to apply for RentHelpMN.
I'm not exactly sure that the landlord is accomplishing anything by sending this letter. It doesn't really have a legal impact on the tenant status. It's a scare tactic for sure. Hey, as soon as we're able to, we're going to go file an eviction. It doesn't mean the landlord can file an eviction or even non-renew at this moment. So this is the kind of thing where we'd want a tenant to call us directly. We'd walk through it. We'd look at the notice. We'd probably look at the lease, make sure we're not missing anything. And so please feel free to have people contact us on our free tenant hotline or our email and attorney service.
Definitely your turn now, Eric.
Yeah, I was just going to jump over to the slide that has our phone number, but there we go. Okay, Mary asked, if an applicant is denied for not getting info submitted in time and there's no appeal, can they reapply?
So our reapply button is now active for those that qualify to reapply for assistance. So if there was a reason, depending on the declination, will depend on whether or not they need to apply or appeal or reapply. So if that person has an application, they can go in, see if the reapply button is there, and then do the reapplication.
Okay, this is an anonymous attendee from a landlord. If an application is incomplete due to the tenant's failure to give additional information and the resident has ignored landlord's request for more information since July 6th, is this considered to qualify under the tenant's refusal to apply? Landlord preferred to get the back rent owed.
So for the rent help program, an incomplete application is not a submitted application.
And also I would just, I don't think that we're going to try and determine what refuse is on a case-by-case basis. I just really would encourage you to seek some legal counsel if you're trying to determine whether or not actions taken by your tenant are refusal or not.
All right, another anonymous question. Why have several of our tenants gone from submitted funding back to initial review? A landlord, I guess, in the portal is saying that.
So that would be based on what is going on in the application. They can change, the application status can change, and until payment is sent, the application will change.
Michelle, is that something that you would encourage them to maybe email the landlords to see why it would go from submitted payment back? Or would you encourage?
Yep, so if it goes back and there isn't any communication but it just depends based on the graph that we have that shows the different, what's going on and the different statuses, there may be something that has changed where we need to go. One would be if the landlord gave a ledger and it doesn't match the original assistance and now they would like to add it, it does have to go back to initial review so that the applicant can go in and make sure that they want to accept that assistance.
All right, Sherry is asking how many applications have actually been paid out compared to how many applications have been submitted.
So we do have a link for our dashboard on our website. It's in the news section. It has the up-to-date information as of a certain date. It does say on the bottom which date it was updated for application funding that was submitted, what is out there now and pending applications, the amount of assistance that has been sent out, the number of applications per county. So I would suggest that you refer to that when you have questions as far as the exact amount of funding that we've submitted.
All right, James's question. For evictions for non-payment of rent on the exception where the tenant refuses to apply, cooperate in application for assistance or provide proof of application, who has the burden to make this determination? Does the tenant need to provide proof of application after receiving the 15-day notice or proof to the court if an eviction summons is issued?
I might need to see that one. Mike, do you want to take a stab at it?
Well, I mean, my thoughts on it is I think the landlord has the burden technically. I think that has to be the right answer, but it's sort of like a unauthorized occupant case where if the tenant has really hard, credible evidence, for instance, let's say the landlord accuses the tenant of having her boyfriend live with her. The tenant provides the lease of the boyfriend somewhere else. It can be, it's not an automatic win for that tenant, but it can really help in the argument here. I think if the tenant produces the evidence that they did apply, it could be, as lawyers say, dispositive. That could be the end of the case. If they can show, oh, I've got a pending application, you need to back off with your eviction or stop the eviction that's already started. So although I think technically the burden is on the landlord, it's very disprovable by the tenant. So most tenants are going to want to be pretty active in doing that.
Because the session law does say that a tenant needs to provide that proof.
Well, they can be evicted for refusing to provide it, right? So that part shifts the burden. The first two parts don't necessarily. So it depends, I guess, a little bit on what the landlord alleges. Although I think they're using the catch-all probably of all three. That's how most landlord attorneys would do. They're saying they've either applied, I'm sorry, that they've refused to apply, and they've also refused to provide the proof or the information to the landlord. So again, I think the landlord has to make the allegation that the tenant didn't comply with this. Technically, I still think the landlord has to, I suppose swearing under oath is part of their burden, but the tenant is the one that can disprove it actively. I don't know how the landlord can prove the negative on that one.
Okay. All right, I'm going to move on to the next one. So this one's from Anonymous as well. It's really more of a comment regarding the landlord email at RentHelpMN, saying we sent several messages starting on the first day it went live through last week to the landlord rent help email and have never received a reply and no help from phone calls either. They say they're doing the first come, first serve, yet there's been no reply. And this landlord is very frustrated for both landlords and tenants who are trying to get help.
So in that case, I will reiterate that sometimes the landlord will send us information. They need to change the property doesn't match. They will leave a note or change the process. If a landlord says that they would like to add 3 months, they leave a note in the application. So when the caseworker is processing the application, just like when 211 takes a note, they can look at those notes and see what needs to be changed. So sometimes a response is not always needed.
And I think this is also kind of a comment from a landlord who says there needs to be an additional option to change information in the rent help website by the landlord. Some tenants may not understand there's a difference between a management and an owner, specifically that one management company may have multiple client owners. Multiple residents have been applying under the correct management company, but the incorrect owner. It would be more efficient if landlords would be allowed to revise that information instead of telling applicants to call 211 or make the change. So I guess just a comment, unless there's any.
All right, Sherry would like to know what happens when a landlord declines the assistance.
Then we can verify with the tenant and we will mail the payment to the tenant.
Okay.
All right, Mino asks, if a tenant has applied for rent help and is pending, but end of lease term is near and they move out, will the funds, so you've already answered this, will the funds, if approved, still be sent to the landlord? Does the tenant have to remain in the home and wait for the payment to be received from the landlord in order to move out? Yes, they do.
So yes, they have to be an occupant of the unit.
So this is anonymous. Some of this I think has already been covered, but I'll go through it. We had tenants apply in April and request 3 months in advance, May, June, and July. Since then, they now have late fees as unpaid and trying to request 3 months for future August, September, October now. But we received notice it only counts 3 months from when they applied. So now they have to refile for the current months, question mark. August rent will be due soon. And since we haven't received funds for April applications, we don't have hope for future months.
So if the application has already been paid out, they will have to reapply for future months rent. If the application is still pending, the caseworker is verifying if they're eligible for 3 months of future rent prior to finalizing the application.
What is the Andrea asked, what is the minimum information needed for an application to be complete?
So we do have a checklist on our website for landlords and for applicants on what they need to fill the application. I will say that if the application, the more complete, the more information that is submitted, the smoother the application process goes. If an applicant just goes through, clicks buttons, clicks submit, then their application would not be considered complete and would need to go through further processing.
All right. Shannon would like to know, when the payments arrive, are the checks mailed directly to the landlord or to the applicant?
If the landlord chose to participate, the payments are made to the landlord or the utility provider.
And this one's been answered already. What if the landlord doesn't want to participate? What happens if they're not participating? You've said the funds will go to the tenant. I'll just jump to the next one. Sherry asks if is there anything in the works for landlords who have had tenants skip out due to the no eviction mandate?
Not that I'm aware of for the rent help program. We do not have any funding for tenants that don't occupy the unit.
Right, and then of course that is a requirement of the Treasury.
Yes.
And so this is again the hundreds of millions of dollars that have come in from the feds that this program is operating under, and that's tied to the phase out law, does have that requirement from the Treasury.
All right. Scrolling down. All right. Sorry, some things just shifted in the Q&A, so it got a little, I'm not certain. All right. All right, so I think this is a landlord, and this is from a landlord, is what it says. And anonymous, more of a comment again, basically saying, why should the landlord get shafted? The tenant applied in April and we're still waiting for the app to be reviewed. And now the tenant moved out. Not only is the landlord getting the short end of the stick, but now it is the tenant. So is the tenant, because they have a debt they cannot afford to pay back, and it will go against their credit history and rental reference.
Yeah, and again, as Eric pointed out, I mean, just to comment on that is, we at Minnesota Housing, I mean, we've heard that over and over and over again, that, you know, someone moves out, there's no way for the landlord to collect the back debt. And unfortunately, because this money is coming from Treasury with a lot of oversight and regulations, we cannot pay after someone has moved out. We have to pay under a existing tenancy that has a contractual tenancy. So I hear you, and believe me, you're not the first person to have said that to us. But unfortunately, our hands are tied in that instance, because Treasury requires the tenant to be in the property.
All right, so plugging along. We got a half an hour. How's everybody doing? Get a drink of water? We're all right. There's a very detailed question from an anonymous landlord that I think, I'm not going to repeat all of it, effectively is a question about material violation of the lease. Some of the complaints that they're getting, they claim the tenant is causing a disruption of peace and safety. Complaints by surrounding neighbors of loud arguments, slamming doors, resident daughter allowing dogs they were watching. I guess maybe dogs. Yeah. Lease states that residents may not have visiting pets. And so they had, and they made a mess in the carpet, in the hallway, etc. So I guess it's kind of a general question about material violation for Mike or Rachel.
Right. So a material violation, a landlord is allowed to file an eviction for right now. As of last Wednesday, they are allowed to file an eviction for material breach.
Or terminate the lease if they don't want to file. They could also just terminate the lease as well, right? With a written termination.
Yep. Sure, they can give a notice to terminate. They could have done that a week before for that reason. So the landlord has had that right. And so if the landlord says, I want to non-renew your lease at the end of September because of this material violation of the lease, they can do that still at present. Is this a material violation of the lease? Well, that's the kind of thing that courts really do decide. It can be very subjective. There's enough here that maybe is the answer. I would say absolutely not if I didn't think it had a shot, but a landlord could win this case. They'll have to develop the facts, maybe produce witnesses if the tenant fights it. The tenant might just decide to move out at the end of September. But yeah, a landlord can give a notice to vacate non-renewal for a material breach of the lease at present, or file an eviction.
All right. I think this might actually be one for Mike as well. Anonymous is asking, if a landlord accepts payment, does that stop them from evicting for a certain period of time for allowed reason under the law?
Maybe. I think what Anonymous is asking about there is the concept of a waiver. I think
Yeah,
that's what they're getting at here.
Getting.
Right. Like if the landlord is accepting rent, knowing about a lease violation, have they waived the right to evict? And the short answer is maybe to probably, somewhere in that zone.
Okay, I'm going to jump in here with a question I saw in the chat from Jolette, a case manager, who's wondering, what are some common reasons that applications are being denied? And related to that, do children count in the income limits? Example, 2 adults, 4 kids, would that be considered 6 people?
So common reasons right now that applicants have been denied is that they applied for future rent, which is part of phase 2. So they wouldn't qualify for the phase 1 program. They don't meet the eligibility requirements. I know some jurisdictions are declining that are processing their own cities are declining because they have no response from the applicant. Yeah, there has to be like a reason for the declination. We just don't decline because of the application is incompleted or something like that. And then the other one is the household size is the number of people in the household. So if there's 5 children, 2 adults, that'd be 7.
The denial information that a tenant gets, it'll say exactly what the denial was for.
Yes.
All right.
Okay, Heather is a service provider, I believe, and wants to know is there is a contact for RentHelpMN that service providers can use to help tenants. Sorry, if they are, say a tenant gets additional support through like emergency assistance or something like that, but then the service provider finds out that they have a pending rent help application as well. Is there a place that the service provider can report that they've been able to help the applicant, or is the expectation that the applicant will inform you that they received help elsewhere?
So if you have the applicant's information, say name or application number, then you can definitely call 211 to leave the note in the system and then where you're from. And then we will verify when it's time to process the application based on the information provided that we will, that they've received the assistance or not. And then 211 also has contacts within the organization and the processing and the case managers on who they would also let know as well.
Perfect.
I'm not sure I follow Valerie's question entirely here. Tenants are getting, it might be related to the last one, tenants are getting calls from case managers, but then are unable to enter in the information they requested to the dashboard. What should they do?
So if the application is submitted and doesn't say need applicant response, they will not be able to upload information into the dashboard. So the application has to requires applicant response for it to be opened again. Applications and landlord registration cannot be changed after it's submitted. So they can call 211, 211 can let the case manager know, leave a note in the system. They also have the option to send their caseworker communications in their dashboard through the communications tab with questions, concerns, and then that way the caseworker will know what's going
on. All right, so Lucas, landlord, is saying that during the landlord approval process, it asks if we want the money sent to the owner or the management office. We've selected management office, but the checks are always being sent to the owner, delaying the money being applied to the resident's ledger. Is there a way to update this preference for a property that will actually result in the checks getting sent to the management office?
So this has a lot to do with the process or the registration of the landlord. So if the landlord registered and they put in the contact information or the payment information where it needs to go, then it will go to what was registered through the landlord, not who they spoke to on the phone approving the payment or verifying the information.
They should go back to their dashboard, Michelle, and make sure that the address is the right address that they want to go to.
Yes.
All right, and then a comment from Sharon from CRC, mediation organization, who says they will be working in the court to make sure people get access to RentHelpMN from court. So I think that was regarding the in Hennepin County, how is that going to happen? But again, those are virtual for the time being. And so that there is a way for tenants who are showing up for initial hearings to talk to folks, legal aid and others.
Okay, so Anonymous has kind of two different questions. So they say that the phase out legislation only stated that RentHelpMN and Zero Balance Project as the only programs that were allowed protections under evictions. Is that correct? Or will phase out legislation be changed to allow for other programs? So I'll take that one. The phase out language actually just states, and I've got the language up here, it defines a COVID-19 emergency rental assistance program means any rental assistance program authorized under the Federal Consolidated Appropriations Act of 2021 or the Federal American Rescue Plan Act of 2021. So it's not, those two programs are just the current programs that are widely available. So it's not just RentHelpMN and the Zero Balance Project. If there are other programs that end up being funded through that money, then those would also count under the phase out as for protection. And then this one is definitely for Michelle or Lael. They're saying several field partners are providing incorrect information to tenants and therefore causing false appeals and complaints with a legal aid and the Attorney General's office.
So for that one, I would like that information so that we can look into it and what is being said, and if the field partner is actually part of the program, one of our community partners, because I don't know based on this what was being told or who told it. So that is something that they would need to reach out to me and give me that information, and then we can do some further investigation, some further coaching, whatever needs to be done. We don't want to cause any issues. We want to make sure the accurate information is being told.
So is that an email to the landlords at renthelpmn.org? Is that the best?
Let me see where we should send that.
Okay, Leah is a landlord and asked, why would an applicant be under supervisor review?
So sometimes we sporadically check applications. We do quality assurance on applicants, landlords, and that's why it goes to supervisor review.
All right, so this is from a service provider saying that they have participants asking them to provide proof of their MFIP benefits for RentHelpMN. Is a document from me where I essentially copy paste their MFIP award amounts considered adequate? I don't have a way to send anything more official, and given the system, representatives from the county take weeks to receive and respond to these types of requests. So participants ask them.
So this is kind of a twofold question. We do have proxies in play for those that meet certain eligibility requirements based on land or based on where they live or zip codes that may negate that needs to be sent in. But award letter is more, we would prefer an official award letter versus something that is copied and pasted from your computer so that we know that it's actually something that was received.
Michelle, we also have a verification form or like a self-attestation form that says like, I receive income, I don't have proof of it, here's my things. So you could also, the applicant could also do an attestation of MFIP, that this is how much they receive, sign it, and then maybe even include the screenshot. I mean, I think what you said, Michelle, about like our preferred is some sort of a official award letter.
Yes.
There are other avenues that would be acceptable.
Anonymous question. I think a landlord, a little bit difficult to follow. When we verified with RentHelp and the tenant and us requested an additional 3 months going forward. So that was for July, August, September. RentHelp has said it only counts through July. The tenant applied in April. Does it sound?
So there could be a number of reasons why this happened. If the applicant had April through April rent, that is 12 months. July or May, June, and July would make it 15 months. They would not qualify for future rent at this time because they have met their 15-month threshold. So it just depends on the situation. And for that, I don't know. I don't know how much assistance they had asked for in April up to April, but it is a total of 15 months of rent assistance.
All right, this is, I think, maybe a question for all parties involved. This is from a landlord attorney, an anonymous one, saying that, asking again, how do landlords prove that a tenant isn't eligible for rental assistance in order to commence eviction actions on August 13th? Also assume that a landlord can evict starting August 13th. Does the 15-day notice need to be sent on August 13th or later, or can it be sent before August 13th?
So I think there's some interchangeable stuff here that they just have wrong in the question.
Yeah.
Yeah, so August 13th is, remember, the weakest of the, I don't know if Eric, if you can go back to the slide that shows the chart. August 13th is the date that landlords are allowed to give a notice that the tenant has been ruled ineligible, or is ineligible, I should say. Lael will correct me on the right phrasing on that. But it doesn't let a landlord file an eviction that day. That doesn't happen until September 12th. So the question is saying, can I evict on August 13th? There's no right to evict, there's no new right to evict starting August 13th for landlord. There's a right to give a notice August 13th. So that question, we can just kind of morph it into September 12th if we wanted to, I suppose. And so if the eviction could be commenced on September 12th, can the landlord give a 15-day notice for non-payment of rent prior to that? I think so, is my best guess. I think that's the right answer. We haven't gotten to those stages yet, but I think that's probably the right answer.
I agree. I think since September 12th is when they can start being
So
filed.
whatever that would be, August 28th or whatever, right?
Yeah. And yeah, we did cover a little bit about what a landlord needs to prove that a tenant is ineligible, and it's a denied application is certainly something that would be usable, but there's no real set thing that's going to be up to the courts to decide really what's going to be sufficient.
Right, and again, the eligibility for the program is on our website, so you could go and see, you know, what you'd have to prove they were ineligible for. So, you know, if you can prove that they're not under 80% AMI, if you can prove that they, you know, one of those pieces, again, that may be difficult for a landlord to do, but that's going to be for a court to determine if your proof is good enough, basically.
And 45 or a half an hour ago, I said we had 30 some left. Now we have 38 questions left. We're taking ourselves into a hole here. So
that's just bad math. That's just bad math.
I don't know how to turn off the Q&A system.
Unfortunately, I have a hard.
Yeah. So I mean, we got plenty of questions here. What we will do is maybe send those questions over to Lael and Michelle, and so that they know, you know, some of the questions that are coming up. But we do have 10-15 minutes left here, so we'll tackle a few more. But at this point, you probably don't want to submit a question because we're not going to get through all 38. Following up on Lael, you just said we're talking about eligibility. This is an anonymous question. Do applicants have to be legal U.S. citizens and show proof to be eligible for assistance?
This program does not ask any questions or require any proof of citizenships or document status.
All right. So this anonymous is saying, I understand that I can adjust through status as being reviewed, et cetera, but how does it go from approved for funding back to initial review? Once submitted for funding shouldn't have been approved, so why does that particular status change? It has done this several times, asking for ID, lease, et cetera. What was already part of the original submission that was approved?
So we've answered this question about why it changes back and forth. There can be a number of reasons. As far as asking for a documentation, it could be because the documentation that was uploaded isn't legible, isn't up to date, there's something missing. So our caseworkers ask for information, for up-to-date information. If the application was submitted in April, the ledger that was submitted in April will not be up to date for a process in July. So they are asking for additional items.
So specifically for that question, if something is showing as approved for funding, it can still shift around in
Yes.
its status. Okay. I think
The
that was
last
the,
status will be payment sent.
okay. I think that was the meat of the question there.
And Mike, you're right. I was looking at the wrong number, so I was doing the wrong math. We only have 8 questions. That's much better. Okay, anonymous. And maybe we've answered this. Is there a better email or contact for landlords who are having technical issues? We're working with tenants and we both keep trying and going in circles.
So we do, the landlord's email is what we have set up to assist with landlords with questions with their application. If you're not I've made note of some of the questions here and we'll follow up on it to verify that things are being taken care of in a timely manner.
Okay, this is another one just asking a question that's been answered. How long does the application review process typically take? How many applications are pending? I know that's on the dashboard, that last part. And the review process is...
we don't have a timeline right now. We are processing applications as quickly as we can with the information that was given to us. We would like, yes, we will acknowledge that we do have a backlog and we are working through that backlog to get those pending applications that are maybe from April, May, June completed. But right now we cannot give a definite timeline on how fast applications will take.
So I want to jump in here and say that it's really important, I think, for everybody to understand that because of the oversight and the compliance requirements from Treasury, that every single application that comes through has to have a person touch it and review it and look at it and double check it. And so, I mean, it's not as easy as, you know, going to Amazon and clicking on I want this and then it being sent out. Unfortunately, it slows down the process quite a bit, and each individual is so different as to what they have submitted and what they haven't. I know that it's frustrating to wait, but you know, our commissioner has just said over and over again, we're working through it. The checks will go out, people will get paid, but it really does need a personal touch on every single one of those applications that comes through, and that's just we don't have any control over that part of it.
And that's a good comment Lil just made, kind of related to this next question, exactly why there is a sort of individual personal touch on each application. This anonymous question: who governs the reporting to RentHelp on other things paid as utilities, rent to RentHelp? Is there anyone overlooking these to ensure there's not a double payment?
Yeah, do you want me to tackle that one, Michelle?
Yes.
So it is, because it's a federal program, we do have quite a bit of compliance and oversight required by the Treasury Department. We have a process in place for, as Michelle pointed out, for reviewing, kind of randomly reviewing files by supervisors to make sure that things are being done correctly. We have quality assurance happening all the time. We also have ongoing deduplication efforts with other programs like Zero Balanced and emergency assistance and energy to make sure that payments aren't going to 2 different people. And actually, sometimes that's what slows it down, because understandably, tenants are applying wherever they can, you know, and are applying to a bunch of different places. But what that means is that then the organizations or the programs are having to then go and check all of these and decide which program is going to take the lead, and then getting rid of all the stuff from the other programs. And there's a lot of oversight and a lot of touching of these applications necessarily to make sure that we aren't duplicating payments, to make sure that they're going to the right people, that the money's getting paid to the right people, even if it's the management company instead of the owner, that it's getting paid to a verified rental provider. So that's why why it slows down, but that's all the oversight that we have.
Thank you. All right, Jean is asking if the notice, and I think this is going to be for Mike, if the notice is not for non-payment for rent, you still have to have the 3 items. I think
Oh, so how much is the rent? Here's the rent help address.
then you
and-
could be evicted.
Right. No, if the notice is not for non-payment of rent, then these 3 items aren't required. It's only for non-payment of rent that those are the 3 items that are required. I think that's what the question's about.
Yeah.
Although, I mean, you can only give notices for certain reasons right now.
Right. Material breach would be one of them.
Mhm.
And the other ones that were there when we still had the executive order in place as well. But I think the question is asking what we were just talking about there.
Yeah. All right. Jen asks, I joined late. Sorry if already answered. How is it determined if the applicant had a COVID related issue that led them to not being able to pay rent versus the issue not being COVID related and needing to go through traditional assistance methods like EA or FHPAP?
So, Lael, do you want to answer that one?
Sure. I just think that Treasury has allowed us to be very liberal with this. It actually says it needs to be either directly or indirectly related to COVID. And so what that means is that you may not have lost your income, you may still be working, but possibly because schools have shut down, your childcare was higher. And so you weren't able to pay your rent because you were paying childcare, or, food is more expensive because your kids are at home because they weren't able to go to school, and so rent wasn't able to be paid. All of that is COVID related. And I think that really it doesn't need a specific drawn line. If it is indirectly related to COVID, then it's being determined to be COVID related. Michelle, do you have anything to add on that?
No, I mean, they do ask the questions inside of the application, and you do have to make a selection based on what your answer will be.
Right. There are some offerings of how it is COVID related.
All right, this is a question from Andrea. I think this is going to again be for Mike. Can a landlord send a letter to the tenant saying that they have 30 days to get out, but does not provide the reason? Would the tenant have to leave, or is this where the landlord needs to file for an eviction for lease violation?
There's a lot actually there that could be wrong, and we only have a couple minutes left. Right now, a landlord can't give a notice to vacate for no reason. How we're reading the session law is that can't happen until October 12th. If a landlord wanted to give a notice to vacate for a material breach right now, they could do that, but not for no reason. So, and again, the difference between an eviction and a lease violation, the landlord might have to file an eviction if the tenant doesn't go, if the landlord gives a proper notice for holding over is what it's referred to.
All right, Thomas, as a landlord that has a renter in Ramsey County not applying and using the moratorium for a free place to stay, knowing he cannot be kicked out, hasn't paid rent for June or July. Tenant is violating the lease by having a girlfriend, a guest live with him, smoking in the house, and also having friends stay in the house, sleeping on couch. When can I apply for eviction, and when will it pass review?
Well, there's the money part, right? So I'm not sure what Thomas's primary goal is here, if it's to get paid or if it's to get the tenant out. If the landlord wants to get paid, I mean, this is the decision that landlords have to make right now. Right now, they can file an eviction for a material breach if they want to. They haven't been able to do that for months. But let's say they win. The landlord wins the eviction for material breach. They get an empty place. They get the keys back, but they don't get the money, right? I mean, how the system is set up right now, we've been hearing for a couple hours now, is the landlord's not going to get paid if the tenant's not still around. So a landlord has a big decision to make when it comes to, should I file an eviction for material breach if the tenant owes a bunch of money as well? So maybe you'll win the eviction. The burden is on the landlord to win a material breach case. So you have a shot. But again, I think a cost benefit analysis up front from a business standpoint makes a lot of sense for a landlord.
All right, we're barreling down. Only 2 questions left. All right, David is a landlord and they're asking, I've had tenants with funding approved status for 4 weeks. What's the holdup?
So in those cases, I would definitely reach out to the landlord's email address, let them know the application number, and we'll do further research to see why that it's taking so long.
And Christina asks, what are the next steps when an application is in final review? How long can it stay in final review?
So I definitely would say, look at the infographic. It does have information in there for what some of the steps are in final review. There are other steps that aren't listed there. That's just a basic lease, and we don't have a timeline on how long each step takes.
No open questions.
We made it.
I want to thank Michelle and Lael. That was a marathon session of
Intense.
questions.
That was intense and that was long.
Yeah, and
Questions, though. Good questions.
and you tackled it all, and you're still standing or sitting. I mean, it's fine. But again, a ton of thanks. We just got a message from Nicole saying thank you to the speakers. So yeah, we greatly appreciate your joining us today and going through the program and answering a lot of complicated questions. And that's just the nature of what's going on right now, is that we're in kind of unprecedented time with tenant landlord law, and but also with an unprecedented amount of rental assistance in our state. We've never seen this much assistance to help make renters allow renters to stay in their homes and landlords to get paid and be financially whole during this time. So thank you very much. Just a reminder that next week we will have a landlord attorney joining us, Kim Tennyson, who is a former volunteer on our hotline and then now is advising and representing landlords. She's been on a couple of our previous sessions. And I put a link in the chat about how you can sign up for future webinars. 2 weeks from today, we'll have staff from the Zero Balance Project on to answer questions about that program, just like today on RentHelpMN. And then our page for phase out information, those are resources on our website, plenty of that available too. So I think we don't see any more questions. So I think we can finish. It's 3:30.
Yeah, it's exactly 3:30. Well done.
Yeah, so thanks, Michelle and Lael. Appreciate it very much, and have a good rest of your Wednesday.
You too.
Goodbye.
Bye.